Good morning, sir. You Robert Tran and Mr. Trahan, and clause number 25 DCCR 1094. You're charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. The indictment alleges that you were previously convicted of accident involving injury or death, a special degree felony, October 16th of 2017. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, October 17th of 2022, and also possession of a controlled substance, October 17th of 2022. And so that special degree is considered, have y'all done any research on how that's considered as far as enhancement purposes?
I believe it's considered a third for enhancement purposes.
Third, I've got him at 2 to 20.
No, just right. If that's considered a third or more,
It's not
then it would be
considered.
2 to 20. I just need to know of the special degree, you think it's considered a third?
I believe so.
Which
Just
would
because
make-
the sentence was 3 years, I believe, before one of the two.
I'm confused.
So in the
If it's
indictment,
third degree,
one of the prior felonies that are listed as enhancement is a special degree felony.
I'll say.
And so it's on one date in 2017. The other two are on the same date. And so in order for it to enhance, I need to make sure that it's considered a third or more and not a state jail
Now I understand.
for punishment purposes. And so I want to make sure we are all on the same page. What is the range of punishment for that?
Judge.
Degree. I haven't had one like this in a while, so. I don't know.
they amended that statute to be different now than what it was back then, and that's why it was a special degree in the first place.
Gotta know what it
It
was.
made the minimum.
Actually, Judge, you know what? I have my criminal history here. Let's see what it.
Y'all do this. Let me hold it for
Yeah,
a minute and just double check what that range of punishment was in 2017.
Okay.
Because that would be the law that would be followed. And if y'all need, I have old books. So let's do that first, and then we'll figure it out. I'll just hold the paperwork. Thank you.
This is the judgment. So it is not, the indictment in the cases does not allege serious bodily injury, so it is just the generic accident involving injury, which I think puts you under 550-21, under the last, under the last, the general punishment range. Which is
up to 5 years.
Yes, ma'am. And so that actually hasn't been changed at all. That's how it currently reads as well. And my understanding is that qualifies as a punishable enhancing offense for purposes of habitual offender status.
Okay. All right. You agree, Mr. Cole?
Yes, Your Honor.
Okay. Thank y'all for taking a look at that. Okay, so what that means, let's go back then, Mr. Trahan. In 25 DCCR 1094, you're charged with that state jail felony offense of unauthorized use of a vehicle. And in that case, you've got the prior offenses that we went that I've already gone over, which are 3, 2 on the same date, but then the other one, they are consecutive. And what that means is if you go to trial in that case and you're found guilty and those prior convictions are true, the range of punishment would be that of a second degree felony, which is between 2 years and up to 20 years. Do you understand? Answer out loud, please.
Yes, ma'am.
And then cause number 25 DCCR 1317. You're charged with the state jail felony offense of possession of a controlled substance from December 28th of 2024. The indictment alleges those same prior offenses. So again, what that means is if you're found guilty in this case and those prior convictions are true, The range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then finally, in clause number 25 DCCR 1536, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from August 20th of 2025. And it alleges those same prior felony convictions. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum.
Here's where things get extremely serious. Because of the prior felony history, the third case evading arrest with a vehicle could trigger habitual offender sentencing. That means the minimum punishment jumps all the way up to 25 years in prison, with the possibility of life behind bars.
Minimum of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And in all of those cases, I have here on the computer some documents and plea bargain rejections that you've signed with Mr. Eckhart that show that the state has made offers if you wanted to enter pleas of guilty. And those offers are for, in all of the cases, in the first two to go on all of the counts, and the last one, the habitual, to go on count one only, for 7-year terms in all three of those cases that would run concurrently, which means together at the same time. You have every right to reject that and have all of your cases set for trial.
Now comes the moment that defines this entire hearing, the plea offer. Prosecutors are offering 7 years total for all three cases, running at the same time. But if he rejects it and loses at trial, he could face 25 years or more. This is one of the toughest decisions defendants ever face in court: gamble on a trial or accept years in prison.
Trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. Do you understand all of that?
Yes, ma'am.
And you want to reject those offers and have your cases set for trial.
Correct.
Okay. And I'm assuming, Mr. Eckhart, you've received all the discovery.
You have, Judge. We've got the media, we've got the discovery, and we've gone over Mr. Coleman's offer thoroughly.
Okay. And y'all, with regard to that evading any video, you've gone over that with, had an opportunity to go over that with Mr. Trahan?
Yes, ma'am.
Okay. Then, Mr. Trahan, I want to make sure you understand, Mr. Coleman, is there any reason to believe that there's any other reason or additional evidence that would change your mind on that offer?
Not at all, Judge. In fact, the offer, Mr. Eckhart has done a good job at getting it to where it is, Judge, and I have no reason to believe it'll change.
So, Mr. Tran, I want to make sure you understand you have every right, obviously, to have a jury determine everything in your cases. That after today, I will not accept this plea agreement after today. Do you understand?
Yeah. Do you have all the evidence from the people who testified and
So I don't.
statement, victim statements and stuff?
So you have. I don't have anything. That's not my part of the job. So what Mr. Coleman has, he's required to turn over to Mr. Eckhart. I'm sure he has turned over every single thing he has. Mr. Eckhart has all of that, gone over what they have with you. And then any other evidence is just evidence at trial that could potentially come out. But I'm sure any discovery, written discovery, and media, videos and things like that, pictures, have been turned over. And Mr. Eckhart's gone over that with you, correct?
Well, yes, but also I barely have enough time on Sunday just to talk to my family about anything that had to do with signing for anything. So
Check this out. He's staring at 25 years in prison if he goes to trial, versus a 7-year plea deal. That's a life-changing choice. The judge is making sure he really gets the stakes freedom now or decades behind bars.
So I definitely declined it because I don't have time to talk to nobody about nothing before I could even see if I could, because they were talking about hiring a lawyer to begin with. So that's what she had just told me on the phones. It was just, I really haven't had time to do anything. It was just like a forced play, like a quick thing. And I was just,
Well,
Judge,
like,
I told him that the court will let him hire a lawyer if he so chooses, but they're not going to change his date for his trial based on that. He's going to have to do so before the.
sure. Well, a couple of things. One, obviously, if you want to hire your own attorney or your family does, that's fine. But I do want to make sure you understand that the offer today is the offer, no matter who your attorney is. So they're not going to come in and get a different offer from Mr. Coleman.
Yeah.
So that is what it is. If you would like, I will reset your case 1 week to visit with whoever you want to and make your final determination before you go to trial. This is obviously very serious. I'm not trying to talk you into or out of anything, but if you're found guilty, a minimum of
The judge is making something very clear. Here, once this hearing ends, the deal may disappear. Prosecutors often put time limits on plea offers, especially when a case is about to move toward trial. So the defendant now has 1 week to review the evidence and make a life-changing decision.
25 years compared to 7 years is obviously a very big difference. You've had an opportunity to review the discovery that Mr. Eckhart has. That's not going to change. Whatever the video is, whatever the evidence is, it is for whoever gets your case. Your family hasn't seen all that, but you have. You have 1 week, Mr. Coleman, if you will indulge can leave that on the table for 1 week. I'll
Yes, sir.
reset your case 1 week. We will get an announcement one way or the other next week.
So I can get the discovery and be able to look at it myself. I have to.
So here's the thing, there's specific laws that don't allow defense attorneys to just hand everything to their clients. So he can go over it all with you. You can look at it, but for you to have it in your possession is not allowed. So Mr. Eckhart, if you would go back one time this week, go over everything again with Mr. Trahan, make sure he sees and reads everything, then we will get an announcement next week, and that'll be it. Okay?
The clock's ticking. He's got 1 week to review all the evidence before deciding. Take the deal or risk trial. Every choice could change his life forever. What would you choose?